he will join us later. So we kindly invite our speakers to please get up to the stage. Greetings. Greetings, dear participants, offline and online. Thanks for joining in. Despite the difficulties, the lack of power, water supply, the air raid alert, the shelling, thank you for finding time and opportunity to come here to discuss this important topic, the liability of legal entities for bribing foreign officials. Why is this meeting important? Oh, apologies, my voice resonates. So, some time ago, the work group of the OECD has voted positively to include Ukraine as a member of the work group. So we think that we've made our first step to membership. And this path had been quite difficult. And I remember how Drago Kos, the head of the work group, has asked us in the beginning, are you sure you want to be in the work group? Because the path is going to be very difficult for you. And despite all the difficulties, the war, all the obstacles, we've always responded, yes, we do want it, because our country needs it. We've got the highest political support. We have the work group created by the presidential decree, headed by the president's head of office and chief of staff and deputy chief of staff. They are people who always are the drivers of the active work to achieve results in this area. So next, usually the country has 2 years to do the homework, to implement the clauses of the OECD Convention and the recommendations, to implement it all in the national legislation. One of the requirements of the convention is the liability of legal entities. This standalone liability of legal entities. And yeah, there are discussions among the jurists, among the academia, and the purpose of this meeting is to develop possible changes to the national legislation to fulfill the requirements of the OECD Convention and to bring our membership in the work group closer to reality. We will have 2 parts in this meeting. First, we have the introductions for about 30 minutes, then we'll have a 15-minute break for a cup of coffee, and then we'll have the round table. So, we start with the introductions of the speakers. So, Mr. Stefanchuk, as the person who has a very important role in our movement to the work group, will have the floor first, because it's your support, the support of the Parliament, which is crucial to make our movement very successful. That's one thing. But secondly, you are a renowned scientist. When I've been drafting my speech, I said that several generations of researchers relied on his works. But actually, he's not that old. So, like, a lot of people, a lot of researchers used his works. So, thank you for joining us. Thank you. And first of all, I'd like to say thank you for the invitation, because, now in this difficult time for the state, when there is a lot of political events, it's very rarely we can actually talk about professional intricacies. So thanks, Andrei, for organizing this, for the opportunity to have the discussion, because anti-corruption matters every year become more and more important for the future of Ukraine. And our participation in different discussions, round tables, work groups is an important component in our daily activities. I just want to remind you that this summer Ukraine became the candidate to the EU. And this means that we also have a very complicated task to adapt Ukrainian legislation to acquis communautaire. And one of the comments of the European Commission and the Council of the European Union was in anti-corruption. we have to minimize the influence of corruption on the Ukrainian state. And I think these matters have to be in the priority. But I also want to draw your attention to the fact that adopting a law cannot be an objective as such. And the participation in different work groups, OECD, it's not a goal as such. We want to have tangible results from the application of this all. So it's important when we discuss the notions, when we think of how we can implement them, to make sure that they will have some tangible effect for Ukraine, to eradicate corruption in Ukraine. So in the context of today's topic, we do need to thoroughly look into the notions pre-existing in the legislation and see whether they're effective or not effective, because the matter of liability of legal entities, I think we have to really make it in the focus of our attention, because for now the criminal liability of legal entities has not been implemented by 100%, and the fact that it's linked to prior liability of the officer as an individual, well, it creates still lots of leeway. Civil forfeiture is also often discussed as a tool, but I think we have to develop the mechanism based on the experience of the leading countries in the world, but it has to be fit into the Ukrainian legal framework. So it would be great if you all could help develop specific draft laws to improve this area in Ukraine. So thank you once again for inviting me here. I look into the audience and I see many familiar faces, and I'm very, very happy to see all of you, because I understand that these matters will be resolved, because we all need this. Thank you so much. Thank you, Andrei. Thanks to everyone here. We shall win together, and glory to Ukraine. Thank you, Ruslan. I just heard that Andrei Yermak has joined us. If that is the case... Oh, yes. Good afternoon, Mr. Yermak. As the head of the work group, you are the driver of this movement to the OECD, WG, and you also are providing the motivation for us to make our country more successful. Over to you. Greetings to the participants of this round table. You know, when Joe Biden had been vice president, he said that corruption is cancer which eats the citizens' belief into democracy, and it reduces the potential for creativity. Russia had been abusing corruption globally, and this is a weapon, the weapon which is more dangerous than cruise missiles. Corruption helps the terrorist state undermine free societies from within. The Ukrainian system has shown lots of resilience, and the foundation of its stability is the flexibility and active spirit of our citizens. The whole world sees the result. We've managed to overcome the plans of the aggressor, and Ukraine shall definitely win. But corruption is the most developed and widespread sector in Russia, and it helps Ukraine. We have lots to do. There's lots of struggle ahead, but we shall kick the Occupy out of Ukraine, and we will have to rebuild everything which had been damaged. And to build successful Ukraine, we need to continue the systemic eradication of corruption and open and transparent reconstruction processes on fair and transparent rules for the investors. These are the basic preconditions for the success. And what is success in this context? The large-scale investments coming into Ukraine to ensure growth and prosperity. That's why we have applied to the OECD work group membership. I would like to say thanks to Drago Kos for the decision and the whole work group for the decision to include Ukraine. And this has been a historic decision. It has shown the whole world that we are moving in the correct direction. And I would like to reiterate that this decision is not just a present to Ukraine. This is the result of persistent work of us all to get to the highest anti-corruption standards. And I would like to reassure all of you, every participant of the work group understands that after this decision we have to work even harder, because our objective is full membership in the OECD work group. Also, I would like to say thanks to Christopher Smith. Mr. Smith, it's with the support of the US Embassy to Ukraine. We have the powerful pool of experts, and it facilitates our movement to our goal. With regards to the topic of this event, the liability of legal entities is a complicated topic for discussion among the lawyers, but jointly, I'm sure we'll be able to develop the best way to implement this notion into the Ukrainian legislation. The clauses of liability of legal entities for bribing foreign officials should bring us closer to the OECD standards. I would like to express my sincere gratitude to Ruslan Stefanchuk, the Speaker of the Parliament, who takes part in this event, for his leadership in the legislative process, and to all the participants of the round table. I would like to wish a fruitful discussion. Thank you. Despite the complicated circumstances, and you've seen the events of today in the capital of Ukraine, despite that, you managed to come and to bring your own input to bring Ukraine closer to the OECD standards and to overcome our internal enemy. Thank you for your attention, and glory to Ukraine. Thank you. Thank you, Mr. Yermak. Next, I would like to give the floor to the person who had been always supporting Ukraine, providing wise guidance to help Ukraine navigate the anti-corruption reform. The person who already had been mentioned twice today, Mr. Drago Kos, the great friend of Ukraine and the head of the OECD Working Group on Bribery. Over to you.
Polina, well, good afternoon, ladies and gentlemen. And let me say first that it is a real wonder that you managed to organize such an event in the difficult circumstances you're going through. So you deserve all the respect for that. Second, as it has been mentioned already, approximately 10 days ago, the Working Group on Bribery made the decision that Ukraine will be allowed to join the group as a participant first. This is not the final decision. The final decision will be made by the OECD External Relations Committee in January, but I do not expect any problems there because the External Relations Committee usually confirms substantial decisions of the working bodies of the OECD. So there really should not be a problem. But I have to mention something. You see, despite the fact that all countries in the group share great sympathies with Ukraine as the country in war, the country defending itself, you did not get the green light because of that. You got the green light because you really deserve it. Because, as it has been said already, you did a great job back home, substantially, and also because your delegations in the Working Group on Bribery were always, let's say, presenting a case, let's say, study to follow by other countries how to represent the country. So it was both substantial work and also the way how your colleagues were representing Ukraine in Paris. So now we are here. You're getting the participant status, and you will get 2 years. You got participant status because only 3 criteria have been assessed by the working group. The first one was the incrimination of foreign bribery. The second one was the incrimination of liability of legal persons. And the third one was explicit prohibition of tax deductibility of bribes. Now in 2 years, you will have 2 years to fulfill other criteria, which are much broader, much more intensive, and this will be a lot of work involved. However, having the pleasure and an honor to witness how you work back home and in Paris, I don't have absolutely any doubt that you will do the job. We have, I have to say we have, because this is the case right now. We have cases of countries which did not take the requirements and let's say the rigidness of the working group seriously enough, and they had to ask for the extension the extension of those 2 years period. So I'm absolutely sure that this will not happen with Ukraine. In saying that, and since we are discussing today the liability of legal persons, I have to say that those of us who are a bit older, we have terrible memories of similar topic related to Ukraine from some 11 years ago, when Ukraine has adopted a law on liability of legal persons for corruption to fulfill the recommendations of GRECO, Council of Europe's anti-corruption body. And when the law entered into force, it was abolished by Rada in the matter of 3 or 5 days. I'm sure. I cannot say I'm sure. I know this cannot happen now because this was another type of a country, although carrying the same name. But now we are facing another type of a country, which is serious in fighting corruption. And I took a look. Currently, liability of legal persons is part of your criminal code. And I will not go into details because I know that you will have many of our colleagues speaking about this issue later on. And I can already say that although you have fulfilled the conditions to join as participant, a lot of work will still be needed in this area too. But as I said, I don't have absolutely no doubts that you will do everything needed, not only in this area, but also in all other areas. So what is needed now is to embark on the job, to start working in fulfilling the standards of the OECD Convention, because there's a very strange solution, for getting the member of the working group. You have to ratify the convention, the OECD Anti-Bribery Convention, but you cannot ratify the convention if you are not a member of the group, and you cannot become a member of the group if you don't ratify the convention. So it's sort of catch-22. But there are ways how to get around it. Many countries did so, my own country too. So there are ways, but everything boils down to one. All the substantial requirements of the convention have to be fulfilled. Of course, not into all details, because then otherwise the working group after the accession of the country would not have anything else to do, and we do the monitoring. But let's say the basic requirements of the convention have to be fulfilled, and I'm sure Ukraine will do that. And I only, let's say, feel sorry for one thing. And this is that I will not be able to escort Ukraine to join the OECD Working Group on Bribery as the full member, simply due to the fact that my mandate is expiring exactly in 12 days. But I'll be present under some other umbrellas, and if needed, I will be ready to offer Ukraine any assistance needed. Because I really think you deserve it, because I really think you need to fight corruption, not only having in mind the war which you're fighting now, but also the upcoming reconstruction of the country. And with the staff I met from Ukraine, I'm absolutely confident, let's say, that this country is now turning into something new, something much better, something much more developed, not only in the terms of fighting corruption, but also in general. And thank you very much for giving me the opportunity to give one my last appearances as the chair of the OECD Working Group on Bribery.
Дякуємо, пане Драго, дякуємо за...
Well, thank you, Mr. Drago. Thank you for your consistent support to Ukraine. Thank you for chairing the working group while our stay in Paris. Thank you for your support and your strong assistance. And now I'd like to pass the floor to an individual with the Ukrainian Fun Club established in support of it, because everyone meeting Christopher Smith at least once in its either professional life or professional career or just life, all of them remain amazed with his strength, with his willingness to support Ukraine on its path to becoming a successful country. So floor is given to the Christopher Smith, Deputy Chief of Mission, U.S. Embassy to Ukraine.
Paulina, thank you so much for that kind introduction. Mr. Speaker, Mr. Head of the Presidential Administration, ladies and gentlemen, distinguished guests, I am deeply honored and so pleased to be able to participate in today's event dedicated to Ukraine's accession to the OECD Working Group on Bribery. And I think you all should take great satisfaction and great encouragement in the progress that has been made on this effort just in the recent months toward this goal. I know you've been actively working to amend legislation to comply with OECD standards. And through your hard work, Ukraine finally achieved participant status, an important step on the road to accession to the working group and to the broader OECD. Today, Ukraine is fighting a war on two fronts: a kinetic war against Russia's brutal full-scale invasion, and the longer-term war to win the future by fighting corruption, strengthening Ukraine's institutions, and reducing Russia's ability and other nefarious actors' ability to exert influence in Ukraine. I am confident the Ukrainian people will prevail in both of these struggles, and the United States will be with you in both of these wars for as long as it takes. Just as we honor the bravery of those fighting heroically on the front lines, I want to also recognize the sacrifice, the determination of Ukrainians who have for so long worked hard to create a strong anti-corruption ecosystem. The United States is steadfast in its commitment to support Ukraine and to help each and every Ukrainian in the fight for a secure, democratic, and prosperous future. This is why we welcome Ukraine's initiative to join the OECD's working group. And implementation of the best practices developed by the working group are critical for Ukraine's accession to the OECD and to the EU. I think we all know that corruption entails costs that no country can afford and that no people deserve. It derails progress and directly undermines the pillars of a well-functioning state: economic development, transparent governance, and public trust. And if I could seize on the analogy offered by Mr. Yermak, just as he said that corruption can be more dangerous than cruise missiles, so does meeting the standards of the OECD help Ukraine build an integrated defense against corruption, just as we are working together to help Ukraine build an integrated air defense against cruise missiles and Shahed drones. As we look ahead, it is critical that Ukraine continues to strengthen corporate governance and its anti-corruption infrastructure to ensure a successful and prosperous recovery. Making strong progress during wartime will build confidence among international partners, among donors, and businesses whose role will be essential in Ukraine for Ukraine's reconstruction. Ukraine will not only rebuild, Ukraine will rebuild better. It is for this reason that we encourage Ukraine to start now by participating in the Working Group's 2023 annual review of anti-corruption indicators. I'm confident that Ukraine will capitalize on the experience of the OECD Working Group on Bribery to achieve greater integration with Europe and the international community. I encourage you to leverage the expertise of OECD members to expand the roadmap of reforms in the anti-corruption sector. Finally, I wish you great success in the accession process, and let me reinforce again that we are with you for as long as it takes in the struggle against Russia and the longer-term struggle against corruption. I wish you all the best for the upcoming holiday season, and again, I am greatly appreciative of the chance to speak with all of you today.
Дякуємо дуже, пане Сміте. І я думаю, що після
Thank you, Mr. Smith. I believe that after your statement, there will be even more fans in your fan club. And special thanks to your counterparts, to INL. And we have Jasmine, Elena Gustova, and Yuri is joining us online for standing close to us in our fight against the corruption. Now I'd like to pass the floor to the person who's a kind of a locomotive of our working group, a person who dedicates much of his resources, efforts, and time to coordinate the work of the working group, and he worked a lot in terms of ensuring our membership. And now I'd like to pass the floor to Andriy Smirnov, the Deputy Head of the Office of the President of Ukraine. So, greetings. Thank you, everyone. I will have a very short statement about the people. I'd like to extend words of gratitude to each and everyone for being brave enough to arrive and to visit our event despite the air alert. I'd like to thank the Armed Forces of Ukraine for giving us a chance to have this meeting and to feel ourselves, well, in a relative safety. And big thanks to everyone who participated in our working group on joining the OECD working group on bribery. Because from my experience, I know there's around 100 working groups at different levels. There's working groups at Parliament, the Office of the President, but they're there's a lack of coordination in some of those groups, and they're not working that fast. But our group is really unique. In 2.5 months, we've managed to fulfill so many things. We've filled in the questionnaire. We've elaborated amendments to the legislation. We've offered the statements in Paris. And there's a high synergy at the working group at the National Anti-Corruption Bureau of Ukraine. There's a synergy also with the Verkhovna Rada of Ukraine, with our foreign partners. So this is really a unique level of synergy and coordination, because in some cases, whenever it goes to working groups, you would need to, keep pushing them, because there's always bureaucracy. There's always things that serve as some sort of an obstacle, preventing you from identifying the agenda and moving forwards with the agenda. But thanks to Polina, thanks to our partners from the anti-corruption agencies of Ukraine, in 2.5 months we've managed to do so many things to make such a big step forward that the Office of the President of Ukraine and the President of Ukraine himself, they weren't expecting us to have a fully fledged participant of the working group, OECD working group on bribery. So we need to keep on moving. We need to, come up with the different options for the implementation of those norms and those changes on the liability of legal entities into Ukrainian legislation. That's track number 1, and we will move even further on, because the Ukraine's integration into the OECD, it would require not only the ratification of convention and the introduction of amendments to the Criminal Code of Ukraine as from other legislative acts. There's more work to be done, but considering the swiftness of our work, considering the synergy that we've already developed in this working group, I truly believe that we will be able to take the path towards the fully fledged member of the OECD working group on bribery much faster than for the other candidate countries of the EU. So big thanks to you, dear colleagues, and to our foreign partners. Let me invite everyone to a discussion and, in fact, to coffee break right now. Thank you. Thank you, and thanks to Ruslan Stefanchuk. Now we'll have a break for 15 minutes. So we'll start with the round table, and today the representatives of the working group created by the decree of the working group will have lawyers, academicians, representatives of different companies. Will talk about how to implement the autonomous liability of legal entities for bribing public official into the national legislation. We have representatives of the U.S. Embassy, so thank you for joining and supporting our project. So what's the initial data that we have? The Ukrainian legislation, as well as the provisions under the criminal code, the requirement of the Convention on the liability of the legal entities, and our thoughts of how to combine all of that. As I've already told you, our discussion is not starting from the scratch. In fact, it's a continuation of 2 rounds of talks and focus groups that we had at the level of the Secretariat of the working group. Therefore, I'd like to pass the floor to Serhiy Drozech, the expert, and he will present the results of the discussions and focus groups. So here, Serhiy, you have the floor. And thank you very much. Now, if possible, could you start the presentation? So my name is Serhiy Drozech. I represent the international organization, the Right to Development. Indeed, over the December, we've had 2 fairly large-scale events with the involvement of law enforcement agencies, academicians, and the representatives of different legal communities. So we've used the OECD Convention provisions. Surely you know all of them, and here's these norms with regards to identification of the international bribery and the need for identifying the liability for legal entities. I'm not going to talk too much on that. Speaking on the autonomous issue, we're based on the recommendations of the OECD on further countering the bribery of the officials as of 2021. It says that the legal responsibility of legal entities for bribing should not be limited by the cases when the legal entity or those culpable is prosecuted or so our reading of that recommendation was as follows. There has to be parallel processes of prosecuting the legal entities and individuals, and as Andriy Alexandrovich has mentioned, that in the focus group we've considered that such a liability has to be autonomous. Now, just to remind you on these most recent cases of the use of the convention, and the first, as you've seen, was the Siemens case. That's the German corporation case. There was investigation in Taiwan, China, Israel, and Germany. As the result, the corporation has paid to the governments of U.S. and Germany over 1.6 billion USD as the fine and penalties, and as the avoided benefits. 800 million was paid to the USD, then to Norway and to Denmark. So the second largest case was the BAE, that's the British company, on the supply of defense contracts, and it was done in South Africa, Chile, Czech Republic, Tanzania, and Qatar. And also there was bribery of the officials of those countries. As a result, the company paid a fine of 400 million USD. Then there was foreign compliance monitoring for 3 years. And then an Airbus case, and the individuals were prosecuted for bribing the officials in Germany, in France, and some other cases. At the same time, they've made an agreement with the investigation. They've agreed to pay a total fine of 3.9 billion US dollars. So, what's important that the sanctions to the legal entities in the above-mentioned cases that were done in parallel to the criminal proceedings of the individuals for committing a crime of an international corruption. So we need to create a mechanism for accountability of the legal entities that would allow to have accountability for legal entities if their officials or have committed a crime of international bribery, and it will facilitate the investigation both at the national and international level. Now, what do we have in Ukraine? Back in 2014, in the frames of the implementation of the action plan on liberalization of the visa regime for Ukraine, there were changes and amendments introduced, but although unfortunately over the recent period of time there was no profound cases similar to the one that I've already mentioned, and there's no statistics on this category of cases. And in the course of the focus groups, we've decided that the reasons for such an activity could be as follows. First and foremost, this criminal and legal actions, they're taken not only with regards to the bribery, but over a wide variety of crimes and offenses. Secondly, why the OECD gives the recommendation on the autonomous approach, because the prosecution for over a legal entity, that takes a lot of time, and that is a difficult procedure which may result in sentence. And besides, liability of legal entity is not considering these provisions, we've reached a conclusion that in order to have an effective operation of this institute, we would need to provide for the following elements. First and foremost, a special procedural mechanism and a methodology for investigating or not investigation that depends on the model that we would select for the implementation. And secondly, there has to be a mechanism of the international legal assistance in terms of proceedings against the legal entities. Then there are certain limitation measures that could be imposed against the legal entities until the decision is taken. Fourth, there is a possibility for offering an effective protection of legal entities, then a possibility for making agreements with the legal entity. That's what I mentioned. And then there's a widened list of sanctions that could be used against the legal persons. And on the overall, we've reached an agreement that there could be two global models for liability of legal persons. First is to try and develop the current mechanisms through the introduction of the autonomous liability of legal persons. We believe that the advantage of such a model is as follows. It allows to receive the evidences as part of the international legal assistance. Besides, we would be able to do some proceedings against legal persons, and that could be done by the pre-trial bodies that are operating also against the individuals. The largest disadvantage is related to the same aspect, that still it would take a lot of time, and considering the presumption of the autonomy and the responsibility of the legal person, that might go in violation to the personal responsibility. The second option is a hybrid one, but still, as we call it, the administrative liability, it's similar to there's several procedural sanctions, or there's just recently there was another mechanism introduced. So we mean receiving evidence through the mechanisms of international legal assistance and their use in proceedings against legal persons and individuals. So institutionally, this could be either done by the pretrial body or the prosecutor's office, similarly to the confiscation or seizing in case of anti-corruption prosecutor's body, or as it's done by the Ministry of Justice in accordance to the law on sanctions. Theoretically, we could have several provisions for different offenses committed by the persons in the Special Regulatory Act. In this case, we'll have a procedure for settling the public-private disputes. And then we have a question when we've discussed in terms of the using the evidences received by the international legal assistance outside of the jurisdiction of the court proceedings. And also, I'd like to cover the other mechanisms which are internationally available and could be potentially used at the preparation of the concept and the regulatory act. So first, in the criteria for the establishment of connection between the individual and legal person.
Once again, if we consider international experience, this individual can be found that they were acting as an agent, or they are a beneficiary, final beneficiary, or they were acting upon the instruction of the legal person. Or the opposite, it might have been the negligence on behalf of the legal person. The other direction is linking the legal person with other companies. And here, the list is quite interesting. I understand that you might have some questions here, but here we've accumulated all possible experience in this sphere, and we would need to pick what would better suit the Ukrainian model. So, in theory, with regards to the question whether a company can be held accountable for the actions committed by its subsidiaries or heirs, that is the case in some countries. Well, here, I will not be reading this slide. You all have had access to it using the QR code. You can read through all of this. Another legal institute that is available in some jurisdictions, this is the remedies and restrictions which can be imposed. For example, there can be a ban on the dissolution of the legal person, and the law enforcement representatives, they said that it's very, very timely sometimes. Also, they freezing the assets, freezing bank accounts, temporary suspension of the officers or the employees of the legal person, blocking the transfer of assets which could lead to the insolvency of the person, temporary limitations in the participation of public tenders, or suspending the licenses, and monitoring the operations of the legal person. This is similar to the BND. With regards to the sanctions, so the criminal code has fines, asset confiscation and liquidation. So the experts in the work group have led to the conclusion that if we want to hold the legal person accountable, the fines are the best sanction, because, well, they can be scaled up depending on the severity of the act, and mandatory thing is to implement clear criteria for the application of the fines in order to prevent too much discretion of those officials who will impose these sanctions. In other countries, other possible sanctions is a ban to receive state subsidies or dotation, the ban to take part in public procurement, limitations on business activities, and cancelling public contracts, licenses, or permits. With regards to the deals or agreements with the legal person, so which circumstances can facilitate entering the prosecution deal with the legal entity, with the legal person? If they fully, timely and voluntarily disclose the legal activities to the law enforcement, if they have full cooperation with the investigation, if they accept the responsibility, and if they timely remediate the situation and improve the ethics and compliance program in the legal person. The result of the deal could be a lesser fine, the lack of bans to take part in public procurements, or other limitations. We understand that when we provide such a wide tool set, to the pre-trial agency or any other investigation body, we can have a situation of possible pressure on the businesses. That's why we have thought of possible measures of precaution here. Firstly, we have to have the specific list of individuals and legal persons who can act as agents of the legal person to clearly show linkage. Secondly, the effective tools to protect the interests of the legal person on the stage of the investigation, the procedural guarantees. Next is judicial oversight, which can also be used for the legal persons. And the last criteria, and the last is specific criteria to decide on the sanction, which most probably is fines. So what are the possible further steps here? In theory, we would suggest developing first the concept of legislative changes, considering that the topic is really timely and it might be controversial, so to finalize the general concept, and then we could start developing the specific draft regulations and laws. And as I said previously, depending on the model Ukraine chooses, we would probably either amend the criminal code and criminal procedure code of Ukraine, or we could adopt a separate law outlining a separate procedure. This is it from me. Thank you so much. Thank you, Sergei. So now we see that we've had several possible models for holding legal persons responsible. Everyone will have a chance to speak, and to comment on this presentation. And now I'd like to give the floor to our international partners. Why? Because we have some very successful cases of holding legal persons accountable internationally. Let's start from the United States. Here we have the head of the FCPA unit from the US DOJ, David Last. David, we have selected our speakers at this event very carefully, and your participation is very important for us because in the DOJ it's your unit which investigates foreign bribery. And what's interesting for us, in your investigations, you use FCPA as a specialized law, and you have quite a long list of successful cases when you were holding legal persons accountable. So how does it happen in the US? How the whole institution of the responsibility of legal persons came up, and whether you think this tool is effective or not?
First of all, thank you very much for the invitation. It's an honor to be here today. And it's an honor to be speaking with everybody. Obviously, our thoughts and prayers and support go out to the people of Ukraine, and we know this is a very important time to be having this kind of conversation. So thank you. In terms of holding legal persons accountable, that's obviously a big part of what we do at the DOJ and in the United States in the fight against global corruption. From our perspective, it's both sides. It's deterrence as to individuals and deterrence as to legal persons or companies. And in order to hold companies accountable, you obviously need to have, at least under our system, there needs to be a person at the company or more than one person at the company who's acting on behalf of the company and holding the company accountable and is acting in a way that at least is in part to benefit the company in their actions. And it's been a very, very big piece of what we do in order to have a consequence and in order to have deterrence in those cases. A huge part of why we've had this success is, quite candidly, is international cooperation. It's the support and the back and forth that we have with other countries who are in the fight against corruption. It's sharing evidence, sharing information, referring misconduct when we see it. That's a huge piece of what we do. Just to step back for a second, under the FCPA, or the Foreign Corrupt Practices Act, which is our primary criminal statute to prosecute foreign bribery, our jurisdiction is quite broad. And so where we apply that jurisdiction is in three contexts. First, when we have a publicly traded company or someone related to a publicly traded company. Two, where we have a U.S. company or a U.S. person that's involved, or someone acting on behalf of a U.S. company or a U.S. person. And third is when we have some type of conduct in the United States that relates to the scheme that we're looking at. And those are our three sort of buckets of information and three buckets of cases that we might have for jurisdiction, but it does tend to be quite broad. Assuming that we're able to establish liability for a company, which, like I said, relies at least on finding at least one person acting on behalf of the company, there's a variety of paths that we can take. So from the most serious, we could seek to indict the company or charge the company criminally for its conduct. So that's sort of the most severe approach that we could take, is to indict a company and then convict a company at trial. Slightly below that is a guilty plea. So if a company comes forward and wants to admit liability and accept responsibility for its conduct, it can enter a guilty plea for the misconduct. Below that would be what we call a deferred prosecution agreement, or a DPA, where we effectively defer prosecution. We issue a charging document called an information, where the company is charged, but we defer the actual prosecution of that company and allow the company to establish that it's a good corporate citizen and it can make changes so that going forward, it won't have this type of trouble. Below DPA would be an NPA, or a non-prosecution agreement, which is similar, but there's no information charge, there's no criminal charge that's actually filed. It's just an agreement between us and the company, where we agree not to prosecute the company, but again, the company enters into various obligations that they have to undertake. And then below that is a declination, where we just determine in our discretion that there is no criminal charge that we're going to bring whatsoever against that company, and we effectively walk away. One of the things, so under these non-trial resolutions, from guilty plea on down, through these agreements that we have, and all of ours are available on our website. So to the extent folks are ever interested, you could see all of our agreements with our public cases, and what those paths look like and what those agreements look like. One of the things we do under those agreements, obviously, is a fine or a penalty. That is obviously one of the most significant pieces of a corporate resolution, where, from a deterrence perspective, where there's a consequence to the company. But beyond that, and one of the things I always mention when talking about these agreements, these negotiated resolutions, these non-trial resolutions, are some of the other benefits besides the fact that a company is admitting responsibility, besides the fact that the company is paying a penalty. It's all the other obligations that the company undertakes pursuant to those agreements. So, for example, and most of them tend to be 3 years under our system and under the way that we've approached it in the past. But one of the huge things that companies agree to do and obligations they undertake is cooperation. So any further requests that we have, any further things that we ask for of the company, they agree to cooperate for the entire term of the agreement. They agree to cooperate against other companies. They agree to cooperate against other individuals, and they agree to provide that cooperation to us under that agreement. So that's obviously a significant component. Another piece is disclosures. There are disclosure obligations or self-reporting obligations. So if the company learns of allegations of misconduct at the company, it's required to report that to us, which is obviously helpful to identifying further misconduct, whether it's at the company or otherwise. And so that's very helpful to us as well. Compliance. There's a lot of discussion lately about compliance, and there's a reason for that. It's very important. Compliance at companies is in a very good position to identify misconduct, right? Because companies are the ones who are out there. They're the ones who are engaging with third parties. They're the ones who are doing business out in the world, and they're the ones who are in the best position to identify misconduct, whether it's corruption, whether it's fraud, whatever type of misconduct it is. And so having a good compliance program in place enables a company to identify that type of misconduct and do the right thing and report it to us or to other law enforcement authorities. And so part of our agreements is also to enhance compliance and make sure that the company's compliance program is doing what it's supposed to do, which is to identify misconduct and prevent misconduct at the company. And so very often what you will see in our agreements is undertakings or obligations where the company agrees to enhance its compliance program to make it better. Because if very often what we'll see is if the company had trouble, which is often when it's in front of us, is there's been some issue in the past that's happened. Very often it's a failure of compliance, or something was inadequate with compliance, or there's some other issue of compliance. Not always. Sometimes it's compliance that identifies the misconduct and brings it to us. But in a lot of circumstances, it's where there's some shortcoming in the company's compliance program. And so we look to have, as part of their agreements with us, companies agree to enhance their compliance program. And then as part of that, what you'll see sometimes is a monitorship that's imposed. And so there's an independent compliance monitorship that looks at the company's compliance program, looks at the company's internal controls to ensure that the company's programs are properly put in place to make sure that, or ensure as much as possible, that it's not going to run into issues in the future. And so those are the types of remediation steps that we will often see and require as part of our agreements. And so again, from our perspective, it's the fine is obviously very important. The monetary penalty is important, but equally important are all the other obligations that companies undertake as part of these non-trial resolutions, because it makes the company better, it identifies other potential misconduct, and it helps companies sort of not engage in misconduct going forward. And so for us, that's very, very important. And then the last thing I'll say on this is, obviously I started with how important international cooperation is. And part of the reason for our success in the past, if you look at some of our most significant resolutions, Odebrecht, Goldman Sachs, Airbus, Braskem, Societe Generale, Telia, Rolls-Royce, Keppel, there's a whole host of cases that we've had. Part of the reason for the success in those cases is building and developing relationships with other authorities who are engaged in the fight against corruption. And we're working with more and more countries every week, every day, who are stepping up and reaching out to us to have those types of contacts to fight that type of misconduct. It's one of the most important tools that we have, is interacting with these foreign authorities, whether it's at the OECD, whether it's at UNCAC, whether it's just someone picking up the phone and calling me and saying, hey, David, I'm aware of some misconduct that's sitting in Texas or New York or California or Chicago, or wherever it might be. And they might ask, are you interested in investigating that? Are you interested in helping us in our investigation? And my answer is always yes. I'm always interested in looking at it. I'm always interested in helping. Because the more countries that step up, the better this fight against corruption is going to be as we all engage in the fight against it, whether it's gathering evidence, going after bad actors, sharing evidence. It really needs an international effort to work, because all these cases, and I've been doing this for a long time, all of these cases have touches that are all over the world, whether it's a defendant or a target in one country, bank accounts in a second country, shell companies in a third country. And by the time you turn around, you have 4, 5, 6 or more countries that are at issue in any given case with these foreign bribery cases. And so it's absolutely critical that we all work together and that we all provide evidence, whether it's formal sharing of evidence, informal sharing of evidence, whatever it might be, is just hugely, hugely important. Sharing leads for cases, just hugely important. And then the last thing I'll say, and this sort of ties back to non-trial resolutions and holding legal persons accountable. One of the things we've been doing in the United States over the last several years that we've found quite effective is coordinating resolutions with other authorities, where as part of our resolution, we will agree to credit a company's payments to another country. So in other words, we resolved cases very recently. The Glencore case we resolved with and coordinated with Brazil, the United Kingdom, and Switzerland. And as part of our resolutions, we agreed to credit payments that the company made to these other authorities as part of our resolution. And we do that for a few reasons. One, it's the right thing to do. Two, it brings other authorities, other countries to the table, and it helps them in their fight against corruption. And third, most companies, most legal persons are looking for that type of coordinated resolution because it allows them to resolve and to resolve across the board with as many authorities as possible. We can't always do it with everybody. We try to do it with as many as possible. But companies like to do it because it lets them turn the page on the misconduct and look forward to just operating their business and undertaking whatever obligations they have under our agreements. And so coordinating resolutions has been a very significant piece of what we've done in the last several years. And I think it's something we're going to continue to see in the years coming forward. So thank you again for the time to speak today. I really appreciate it. And it's been quite an honor to be here.
Дякую вам, пане Девіде.
Thank you so much. Thank you so much, David. It's been really interesting to learn about your experience. Hopefully in the future we will have the opportunity to see each other in person. Our next speaker is Lorenzo Salazar, and Mr. Salazar is the vice chair of the OECD WGB, the head of the Italian delegation to the OECD WGB, and deputy prosecution general at the Court of Appeal of Naples. Mr. Salazar, I've heard a lot about you from the colleagues in the working group, and it's a pity we didn't have a chance to meet you in person yet, but all the colleagues have been praising your experience. We invited you today because, as opposed to the US, Italy has introduced the administrative responsibility of the legal persons for foreign bribery. Could you tell us how it happened how it had been happening historically and whether this mechanism is effective, whether administrative responsibility is effective. Over to you.
Thank you very much. Let me first thanking you for inviting me. I would have liked to be there in presence. I've been twice in Kiev, and I remember this beautiful garden with a city around, as has been said. Unfortunately, we cannot share your sufferance in order to reduce it, but we can share our experience, and this is exactly what I would like to do now with you. It's difficult to talk about after David last. It should be the last one to take the floor. But I will immediately say that nobody is perfect in this field. Italy has been one of the most, let's say, active members to enforce the convention, and I will tell you why. But the phase 4 report by the Working Group on Bribery on Italy also shows some weaknesses in our system, and I'm ready to share the experience with you. As you have seen, assisting the discussion of the Working Group on Bribery, those of you who had the opportunity to assist to them, I've seen how the robust monitoring of the working group does not allow any country, no matter the size and the seniority of this country, to be exempt from criticism. A criticism, and I want to like to stress this, which is always finalized to improve the fight against bribery in order to create a level playing field, which is the final aim of the convention. So it's not about teaching you anything, it's about sharing different experience which move from different starting point towards the same target. Our legislation, and I answer your question, on liability of legal person was first introduced in 2001 in order to ratify the convention. The convention requested us to implement a system of liability of legal persons. And so under the pressure of our partners, we introduced such a system. This was not an easy task because of the resistance of companies and of the entire economic sector, which were, let's say, reluctant, not to say strongly opposed to the adoption of a system of liability for legal persons, the adoption of which was never contemplated in the past. The principle societas delinquere non potest, the companies cannot, let's say, violate the laws, was still the general principle when I was at the university. So it was really not an easy task. How did we, what we did in order to overcome this resistance, this reluctance by the private sector, by companies, by to accept the introduction of such a regime. We managed to surmount them by introducing a flexible system, which started by providing a liability for legal persons, which was initially restricted to a limited number of predicate offenses, namely corruption, bribery, and fraud. This is the first point. The second point was to call it as administrative liability. After a first period of experiment, the limited number of predicate offenses progressively expanded and nowadays covers basically any serious offense, from the offense against the environment to terrorism, company law, insider trading, money laundering, etc., etc. Our system has been considered as a model for many countries which have legiferated in more recent years because of this, let's say, hybrid nature, and a liability regime which is defined as administrative by the law, but is enforced in front of a criminal court by our public prosecutors. It has also been defined as quasi-criminal or atypical liability, etc., etc. But again, this was made in particular to overcome the initial resistance of the private sector to accept the introduction of a severe regime of liability for companies. This flexibility of our regime of liability is also reflected in the fact that the liability of legal persons is fully autonomous from the one of an identified natural person. I believe to understand that the autonomous liability of the legal person is one of the issues on which there is still work to be done in Ukraine, both in substantive and procedural provisions of criminal law. And we are certainly ready to help you if needed. Nevertheless, also our legislation is far from being perfect, as I said before. And as the Phase 4 report of the Working Group on Bribery indicates, there is room for improvement in many sectors, such as the level of maximum fines available against legal persons, the limitation period, the scarce recourse to interdictive sanctions in the concrete implementation. As I told you, there is one issue which I believe that our experience may be regarded as a model. This is the independence of the judiciary, including our public prosecutors. Our public prosecutors enjoy a constitutional status of full independence, and their investigation and prosecution activities are guided by the legality principle, i.e., mandatory prosecution. It is not without meaning that I refer here to the very same wording which has been used by the European Union when it has established the European Public Prosecution Office, the so-called EPPO, with the statute of full independence. The statute of independence of the EPPO has been largely inspired by the statute of independence of the Italian public prosecutor. Though the principle of mandatory prosecution is formally not of application in Italy in proceedings against legal persons, nobody has ever put into doubt the full independence of our prosecutors in administering their discretion in the sole interest of justice. I cannot but insist on the crucial role that Article 5 of the Anti-Bribery Convention on enforcement and independence on investigations and prosecution plays in the implementation of the Convention. Article 5 is one of the pillars of the Convention. And under Article 5, investigations and prosecution of bribery shall not be influenced by consideration of national economic interest, the potential effect upon relations with another state, or the identity of the natural or legal persons involved. And I stress the word legal persons. Article 5 may be considered as the cornerstone of the Convention, and its enforcement against natural as well as legal persons makes the object of a severe scrutiny by the Working Group on Bribery. The Working Group will certainly proceed to a serious evaluation about the state of implementation of Article 5 by Ukraine all along the accession procedure. And in its path to the accession to the Convention, Ukraine should proceed to a serious check about the full independence granted to the prosecutors and to all the agencies involved in preventing, investigating, and prosecuting corruption. Ukraine can certainly neither be blamed for the war nor for the increased corruption risk which is consequent to the aggression by a foreign state. Proceedings on this check on the independence of these bodies full account should be taken to the enormous challenge which will be posed by the post-war reconstruction, in addition to the enormous stress on integrity in the country already provoked by the war. What I heard until now encouraged me in strongly believing that this will be done. Nothing but a clean environment may better reinforce the trust and confidence of partners and international donors in their effort to help and support Ukraine for a prompt recovery and reconstruction. And here I join the words of Christopher Smith, which I just heard. I'm also proud to be here with you as my last intervention as the Vice Chair of the Working Group on Bribery. Drago said the same before me, and I would like to thank you again for inviting me, and good luck to Ukraine for everything. Thank you very much.
Пане Лоренцо, ми вам дуже дякуємо.
So, Lorenzo, thank you very much. And I have to apologize. but our moderator had to return to his official duties. But I can assure you, Lorenzo, that it wasn't me who had to make sure that Mr. Smirnov had to return back to work. But we're proud of your statement today. We are very grateful for the statement. We thank you for finding the time. We know that you had a court hearing just now, so thank you for finding the opportunity. And Lorenzo, we don't have a room for questions, but the Deputy Minister of Justice would like to ask you a question. Are you okay with that? Yes. I'll be speaking Ukrainian and with the interpretation. Hopefully, Benchuk Alexander, Deputy Minister of Justice of Ukraine. Before appointment to my position, I had a research on the correlation between the criminal legislation in EU and the administrative legislation. So, at that time, my research showed that we didn't have kind of misunderstandings, that administrative offenses, in our understanding in Ukraine, and the administrative liability, it's when, well, let's take some of the characteristics. They're applied to physical person and to an individual, and then if there is any claims against that, then it's done within the administrative jurisdiction. So we follow this procedure. So this is our understanding. What the administrative offense or the responsibility for administrative offenses is different from the criminal offenses. So your experience, I know that in your case, the responsibility, and you've mentioned the responsibility of the physical and of the legal entities, so you called it administrative liability, but still it's not claimed, it's not as part of the administrative justice. It follows the mechanisms of the criminal justice. And you've said that the prosecutor participates in the case, and these are the criminal courts who do the hearing. So how do we proceed in this situation? Because from the historical standpoint, we have a very clear understanding, and we can't hear the administrative offense cases using the procedure of criminal justice. So the hearing procedure and the appeal procedure are very clearly delineated. So possibly a question to you, and maybe you could provide us with more explanations on how to proceed in this case, because it's difficult for me or impossible to consider the situation when we call the administrative offense cases committed by the legal entities, that they would be considered following the criminal justice procedure. Like at this level of our discussion, I can't imagine this happening. Thank you.
Thank you very much for your question. It was difficult to be crystal clear in just 10 minutes of interventions. And it's not without reason that I also use the word quasi-criminal or atypical liability. The definition by the law of the regime of liability for legal person in Italy is administrative. But we don't forget that we started from scratch. Nothing existed before. We had already a regime of administrative liability for natural persons, and this is a completely autonomous, let's say, regime. But when introducing the liability for legal persons, we started from scratch, and we use this word administrative while providing for a regime which is administered into the criminal courts by, let's say, normal public prosecutors in the framework of a proceeding which follows the same path than criminal proceedings. So this is really important to be understood. It was a sort of, let's say, escamotage, the French would say, in order to allow to pass the law more easily. but it's a completely autonomous regime which, let's say, was created in 2001 and which provides for this atypical regime. It's not impossible to think about it because also, let's say, talking about criminal proceeding against legal persons, against a company, is not natural because you cannot put into prison a legal persons or a company. So in any case, we should, let's say, agree about the definitions. What is called administrative liability in Italy is just an autonomous regime for legal persons, taking into account the specificity of any, let's say, regime of liability for legal persons. We impose pecuniary sanctions, which are by definition pecuniary. Either you call them criminal or administrative. This does not change the substance, as much as it does not change the substance if for the other interdictive measures which can be used, we use the word administrative or criminal. In any case, you may shut down the company, you should prevent them to participate to public tenders, etc. And whatever the name, administrative or criminal, this does not change the substance. So again, I want to insist not to stick to the definition, but just to stick to the substance. And again, the word administrative should not be taken into a dogmatic way, but just as the expression which was used more than 20 years ago to have the legislation adopted in Parliament. But it's a completely autonomous regime which was introduced from scratch and which has, let's say, proved to be quite effective. If there is one thing I would like to say about the future of our regime, its need for more flexibility. We heard David before about NTRs, DPA, NPA, etc. This is still not the case in Italy. We have some sort of agreements among the public prosecutors and the company, but we need more flexibility. We should reflect about this in order also to avoid and prevent double jeopardy with proceedings in other countries. Again, I fully agree with David that international cooperation is essential, and I find it essential to provide our prosecutors with the possibility to share the proceedings with other countries in the context of international cooperation, again, to prevent double jeopardy at international level. So more flexibility, we certainly need it, but don't stick to the definitions. Let's be pragmatic. I'm just providing you with our experience, with this quite successful, but also improvements are possible, not from the point of view of definitions, but from the point of view of more flexibility in, let's say, entering into non-trials, resolutions, or similar proceedings. Thank you very much again.
Дякую, пане Лоренцо. Я трошки проспойлерю. Через спікера ми матимемо.
Thank you so much, Lorenzo. And a small spoiler, Brooks Hitman, who will join us soon, will be telling about this delineation between administrative and criminal modes of responsibility, according to his research. Thank you so much, Lorenzo. Thank you for finding time to join us. Now, I would like to give the floor to a country which is quite far from Ukraine, Costa Rica. We have Diana Hernandez on the line with us, the prosecutor. We've chosen Costa Rica specifically because it is one of the youngest countries who has implemented, in terms of the most recent implementation of the convention into the legislation. It happened in 2019. And Ms. Hernandez is taking part in this roundtable because the ENA had been investigating cases against against the legal persons in Costa Rica under this new legislation. Thank you, Diana, for joining us. And I understand it might be early, really early on your side, and we know that soon you will have a court hearing. So thank you that despite all these obstacles, you've found time to join our round table. We are happy to hear your presentation. Over to you.
Thank you, and thank you for having me. I'm very grateful for this opportunity. In Costa Rica, in fact, we just had our corporate liability law. It was enacted in 2019, so it's very recent. And right now, in 2021, we started investigation, 3 investigations against legal persons. They're all for domestic cases. We still don't have any for foreign bribery cases, and it has been quite the change. Previously, the law only allowed for legal persons to be sanctioned by the Comptroller General's office in an administrative procedure that, quite frankly, had sanctions that were very mild. So it was not very common to use this procedure. And also we had and still have the possibility to pursue legal persons civilly if they cause any damage in crime-related offenses. But then our legislation had to change due to international obligations. One of them, obviously, is the requirement from the OECD's Convention Against Foreign Bribery. And we were lucky enough that we had a legislative commission in charge of all of the OECD-related topics, because at the time of the change, we had been a party of the convention since 2017. And our corporate liability law was enacted in 2019, as I said. But Costa Rica was also at that moment in the process of becoming a member of the OECD, not just the convention. However, we did have very long and very technical meetings with all the congressmen and congresswomen to make sure that they understood this importance of this paradigm shift, how companies have been actively participating in corruption crimes in general, and obviously in foreign bribery in particular. This new approach in our corporate liability law, it targets companies that commit corruption crimes, both domestic and international, as well as money laundering when foreign bribery is the predicate offense. This regime is autonomous, just like Mr. Lorenzo was explaining. This is autonomous. This is a responsibility for the company, not for the individuals or the natural persons in the company. We will pursue also, obviously, the individuals under all of the penal and the criminal system. However, we also, at the same time, because it's a parallel process or investigation, we also prosecute all the companies. The sanctions are for the companies themselves, just like the ones that Mr. Lorenzo was stating. We always have a fine, which is the principal sanction. We also can have a prohibition to participate in public contracts, which is obviously where we have most of our corruption cases when companies are involved. Also, we can cancel the contract they have already acquired through the payment of bribes. We can cancel all of their operation permits. Let's say that it's a pharmaceutical company, and obviously they need a whole lot of permits from the state so they can properly function. All of that can be part of the sanction against the company itself. Like I was saying, currently the cases are only domestic. One is against 15 legal persons and 90 natural persons. It's really the biggest corruption case that we've ever had in Costa Rica. And defense attorneys have focused more on the precautionary measures that we have against the companies that the judge ordered, rather than the substance of the law. And this because they're obviously very worried that all of these precautionary measures are, basically stopping them, or we're trying that this precautionary measure stops them from trying to dilute all of their economic grounds, so that we can effectively have a proportionate and dissuasive sanction against them once the investigation is concluded. Just like our colleague from the US, we can have a non-trial resolution, and the company would have to always pay the fine. And we can also negotiate any other term that the company might have to do. One of them could be that they have to accept that they won't be able to participate in state-related contracts for a certain amount of time, from 1 year up to 10 years. Obviously, they would not be fine with 10 years, but let's say 1 or 2 years, because they still have ongoing contracts, unfortunately. It's been a paradigm shift. it was, like I said, since we had a special legislative commission to enact this law, the meetings were previous. So once the law was enacted, there was not much discussion. However, now that the law has been enacted and we have it ongoing, the problem is that we have to make a few changes to the law. So there is a draft bill because we have to comply with some of the phase 2 recommendations from the from the working group against bribery from the OECD. And so now that these new amendments to the law have to be made, now is when some of the congressmen and congresswomen, that it's a different one than the one that enacted the law in 2019, because we had a change of government and a change in the Congress this year in 2022 in May. So this new Congress is now doing, I'm assuming what you're doing in Ukraine, that they go like, really, what are we going to do? Like, are we going to put in jail all the representatives of the companies? How are we going to make liable? How are we going to make responsible a company? Because the company does not breathe and talk and think. But that's why, just our previous colleagues were stating, we have a certain amount of rules that explain how a company that acts obviously through individual or natural persons, how a company has to be held liable. And this always stating or complying within the OECD convention and also other anti-corruption conventions, such as the UN one and the United Nations. And also, since Costa Rica is part of the American continent, we also have the OEA Convention Against Corruption. And all of them require that companies have to be held responsible. And why? Because as prosecutors, we always have seen, not this year or the past few years, like the past decades, we have been clearly seeing that individuals use these intricate structures from the companies to try to really step away or try to dilute the responsibility from the individuals. And also to try to make all these, the assets and all the profits that they make from corruption, from domestic one and from foreign bribery, to try to dilute it and take all of these intricate structures of all these companies, and so that we lose all the activity and also all the profits that they make. Since we enacted the law, we have 3 big cases. Each one is bigger than the previous one. And right now, our biggest, I guess, challenge would be precisely not to convince the judges, because actually there has been a lot of, just like this, a lot of forums, a lot of training for the prosecutors, for the judges, that has been extremely helpful. So the judges now have all been pretty much convinced that we needed this type of criminal liability. Now the challenge is with the new Congress, that they're doing like the second reading of the law that has already been stated. They cannot just eliminate it, because obviously we would be making a breach of the convention. So it's not possible. The law will stay, and the law will continue to be in practice. It will continue to be applied. The problem now is that the new Congress people have to understand that this is a paradigm shift, that it is absolutely necessary, and that these sanctions are not to put in prison the representatives or the president or the CEO of the company. The sanctions, like I said, were for the companies. They are to sanction the company, because just like an individual is acting on behalf of the company, as an individual is acting to help this company do all of this, corruption crimes. And how? By breaching the compliance programs. Every company with a real conscience in this world now, in this intercommunicated world, every company has to have an compliance program, an anti-corruption program, where they have to prevent crime. They cannot just promote it within part of their policies. It has to be quite the contrary. And that's why we have corporate liability law. In the cases that we have right now, defense attorneys have been focusing, like I said, more on the precautionary measures, but they're also very much aware that they do not have a compliance program. They know that they've breached their obligation under the law, because it is a legal obligation, not just an ethical one or a moral one. It is a legal obligation for them to not commit corruption cases, both domestic and foreign bribery and money laundering. So they know that if they breach this obligation, they will have to respond. They will be fined. And as a legal person, because we only think that companies have rights, but they don't only have rights. They don't only have the right to be in trade, to participate in contracts, to hire people. They also have obligations, just like we natural persons have them. So that's what we have in Costa Rica right now. I do have, like Ms. Polina said, a court hearing in half an hour, but I'm very grateful for this opportunity. I hope that this can be useful for the process that has been going on Ukraine right now, and I'm open to any questions because I think I can stay for maybe another 6-7 minutes, and then I will have to leave for court. Thank you.
Пані Діано, дякуємо вам.
Thank you so much, Dana. Thank you for these very important words that you have said. That in your country you, were trying to engage the paradigm shift. I have recently talked to Mr. Klemenko, the head of the Specialized Anti-Corruption Prosecution Office of Ukraine, and he said that at the moment it's very difficult to imagine how in Ukraine we apply this approach as the autonomous regime. And I do hope that here, as we have the representatives of the National Anti-Corruption Bureau, Special Anti-Corruption Prosecution Office of Ukraine, the representatives of the attorney community, the academia, the jurists, that together we will be able to have this paradigm shift, or at least we can start this process, so that if indeed the OECD puts the requirement that we have to have the responsibility of legal persons, then we can think of adopting the legislation so that we would really implement this new mechanism without disrupting the original idea. Thank you so much, Dana. Thank you for this very interesting story about how it goes in Costa Rica, how you advocated the change. Thank you for sharing your experience. So before we get to another important part of this roundtable, the discussion, we have two more speakers who hopefully are very useful in the future for choosing this or that concept of the responsibility of legal persons. These are colleagues from the OECD Anti-Corruption Network. And Brooks Hickman will be the first to speak. As I said, Christopher Smith had his fan base in Ukraine, but now I can also say that Brooks Hickman also has quite a few fans here. We didn't have a chance to talk to each other in person, but we've really read your book through and through here in Ukraine. And we appreciate this because our discussions in the focus groups were based on your research, on your analysis of the data, and on your approach to information. So when we drafted the agenda for today, we realized that you would be the best to help us understand the difference between the criminal and administrative responsibility of legal persons in OECD. So over to you, Brooks. And thank you for finding time and opportunity to join us.
First, thank you very much, Polina, for those kind words and for the invitation. I very much appreciate it. I also would like to just say a second, I'm very humbled to be here. For those of you in Ukraine and for my colleagues and other people, family or friends in Ukraine, but still, despite everything, focused on strengthening Ukraine's legal framework and the fight against corruption. It's very inspiring, and I just want to thank you for your example in this effort. As a small disclaimer, I'm here on my own behalf. I'm not speaking for the OECD or for the Working Group on Bribery. These are just my personal opinions based off my experience working in the Working Group on Bribery country monitoring process, and as well as the study that Polina just mentioned. I'm also very grateful for all the other speakers who just spoke, since they covered many of the points that I wanted to make. But just, I guess, to jump to my conclusion, actually, the making legal changes is quite complex. Every legal system has, as we've heard, its own culture about what is perceived to be the normal process. Is it even conceivable to sanction a company through the criminal process, or is there some other process? So by definition, adopting new techniques, new legal tools is also a cultural question as well, and it requires a lot of work, a lot of thought to make sure that what's being done now tries to anticipate as many problems as possible. Though, as we just heard our colleague from Costa Rica, it's always an iterative process. There always will be things that will need to be fixed later down the road, potentially, and how to manage that is, I guess, the key challenge for Ukraine in this sphere. As Polina mentioned, I was asked to speak about the different approaches that working group on bribery countries have taken in general. We've actually heard them today. The convention actually was, I guess, agnostic. As Lorenzo mentioned, at the time it was adopted, there was a wide range of positions. Some countries had been able to impose criminal responsibility on companies for offenses for at least a century or more. Other countries, the idea was completely unheard of and didn't make any sense. Juridically, how can you have a company sanctioned when it can't be at fault? It doesn't have a mind, it can't be punished. So how do we reconcile this? And as Lorenzo mentioned, the working group on bribery took a very pragmatic approach. The label doesn't really matter. What counts is that in practice, companies can be sanctioned. That said, I believe if you read the commentary 20 closely, I believe that the drafters of the convention probably assumed that criminal responsibility would be the main approach, unless it was impossible under the country's legal system. And in practice, the vast majority of countries in the working group on bribery have a criminal, at least some form of criminal responsibility. Roughly 70% of the countries in the working group today. And the other non-criminal options we've actually heard today already, there's administrative models of corporate liability. I would count, like as Lorenzo rightly pointed out, there's a difference between an administrative model that uses the criminal forum, the criminal procedures to impose sanctions. And there's also certain countries that use what may be more thought of as a more purely administrative model, where the administrative agency that supervises companies can sanction the company. Like, for example, in Greece, the agency responsible for certain obligated companies under the anti-money laundering legislation can also sanction a company for foreign bribery, but that's through the agency process itself. And this also happens in other countries like Colombia. So Lorenzo is completely right. The terminology needs to be precisely understood. And there are many ways to create liability, but the choice that is made may influence the consequences down the line. The last, I guess there are two other forms of liability. One is sometimes quasi-criminal liability. It's called, basically where the legal person's not a direct subject of the criminal code, but can be sanctioned through the criminal process brought against a natural person. And then the fourth one that we heard already as well is civil liability, where the enforcement agency can bring enforcement action in a civil court to sanction the company for foreign bribery, which should be distinguished from a private action by, like, for instance, a company that's been damaged seeking compensation for an injury, which the working group does not consider to be true liability for the offense. So of those four, there are conflicting trade-offs, which actually Sergey from the working group in Ukraine already mentioned many of them. I guess the first thing to think about is what's acceptable as a matter of legal philosophy. If criminal corporate liability is unworkable in a country's system, then by all means, other solutions may be preferred, such as the administrative model in Italy, which also Germany follows a very similar approach, where it's through an administrative quote unquote model, but in fact, it's really being run through the criminal justice system. Another set of issues to think about is how this choice of liability, whether it's criminal or non-criminal, how will it relate to other parts of the legal system? In particular, the criminal procedure code, rules on jurisdiction. There are some countries, for instance, that, to take Greece, for instance, if only the supervisory agency can sanction a company, how can the supervisory agency have jurisdiction over a foreign company? That can become an issue. Statute of limitations may be an issue where there are certain rules for limitation periods for criminal investigations and for bringing a claim to court that are longer than the ones for administrative models, because administrative offenses are by definition seen as less important. Also, in terms of, I guess, the tools that are available to the investigators and prosecutors and the criminal system, usually those enforcement officials have more powers. So that should also be taken into consideration. But conversely, in some systems, if in a non-criminal format, they may have more powers because the constitutional limits on due process or other norms may permit, for example, compulsion of evidence or other testimony that would not be permitted in a criminal context. As already been mentioned, the independence, the norms, several working group countries that have chosen non-criminal means have been given recommendations to deal with the fact that they do not have mandatory prosecution for non-criminal offenses, or especially for the countries that have chosen to have a truly administrative model with the administrator giving sanctions. Article 5 issues, again, become quite important, and there usually are fewer norms and fewer regulations protecting enforcement officials outside the criminal context. And then I guess the last thing to think about is the standard and burden of proof. Obviously, in a criminal context is quite severe. The burden of proof is, the standard of proof first is quite high, going beyond a reasonable doubt in the US context. One argument for having a non-criminal form of responsibility is that potentially it could be a lower form of proof that's required, such as preponderance of the evidence. Although if you have a quote-unquote administrative model through the criminal justice system, I would suspect, I'm not an expert on Italy's regime, but I would suspect that the level of proof is probably equivalent to a criminal model. So you may not, depending on the model that you have, you may not have any real difference between a non-criminal model and a criminal model in this context. On the other hand, you may have an issue with the burden of proof as well. Obviously, in a prosecutorial context, the burden of proof lies on the prosecution to prove the guilt of the liability of the offender, and that's quite a high bar. And I guess in certain non-criminal systems, you might be able to have more flexibility in terms of burden shifting, especially for companies improving compliance. So that may be an argument to favor non-criminal liability, and if you can get the balance right. And then finally, I should point out that some countries have both criminal and non-criminal systems. The US is a good example. The DOJ handles purely criminal matters. The SEC can bring either administrative actions in a pure administrative sense before a judge, an administrative judge within the agency, and subject to the powers of the SEC commission. Or it can bring a civil case to court for enforcement. So just because you have one option doesn't rule out another option. There are obviously pros and cons of having a hybrid model as well. On the advantages, I guess, you have multiple agencies that can specialize and coordinate and help each other. They can divide up cases and priorities in that sense. Another advantage is it may be more difficult if there is a real risk of Article 5 political interference. It may be harder to stop two different agencies than just one agency. On the other hand, it needs to be thought very carefully how the different agencies' powers and jurisdictions would potentially create conflict with each other. If they're both working on the same investigation potentially, is there a way that one agency might tip off the suspects before the other agency, et cetera? So there are many things to think about in choosing a hybrid model as well. In terms of the autonomy, this is not, strictly speaking, I don't think a requirement, or it doesn't have to follow that because you've chosen criminal or non-criminal responsibility that you will have a problem of autonomous liability. I think the only time when this really intersects is when what I call quasi-criminal liability, where you cannot sanction a company directly, but only as a result of having proven that a natural person is guilty or otherwise could have been prosecuted if they receive immunity or died or something like that. And only then does the jurisdiction have the ability, the power to sanction a company. In that type of quasi-criminal model, the conflict of the standard of ensuring that the legal person liability is fully autonomous from the prosecution or conviction of a natural person is the most impossible to reconcile, I think. But for all the other models of criminal and non-criminal, it's completely possible to differentiate, to separate the autonomous prosecution investigation of the company from that of the natural legal person. Although here, I think another advantage to having a purely criminal model is that if you're already investigating somebody for foreign bribery and a natural person, it may make sense for the same set of law enforcement officials to continue prosecuting the same company as well. In some non-criminal models, it has to be the case that the natural person is investigated by the criminal side and the legal person is investigated by the another authority, and that can create some coordination and complications as well. I should also point out that there are certain ways in which the working group, I think, has gone even beyond the prohibition on linking the legal person liability to the prosecution or conviction of natural person, because in some countries they've received recommendations to ensure that the company can be held liable even if a natural person is not identified. I think that, in my personal opinion, goes beyond what's actually required by the standard, which I think I read as more procedural rather than as a substantive link. But Ukraine should be aware of this possibility that there may be a more robust prohibition on linking the natural and legal persons. And then finally, just to conclude, because I think other than the source, and the source does have potential trade-offs and benefits, which is a very important choice to make. The other really important thing to think about is the rules for attribution of liability to the company from an act of a high-level person or low-level official, employee, I should say, within the company. And this here, it's now, I think, Annex 1B, Part 3 of the 2021 recommendation. There are two approaches. There's a flexible approach and an approach that's functionally equivalent. Again, speaking of my personal capacity, the working group, I think, considers these two to be the same. But I think the broader the rules of attribution are, the easier it is to hold people and companies to account responsibly. The more there are rules of attribution requiring proof of a high-level manager's failure or omission, the harder it is on the prosecution to make that case. And as I talked about the burden of proof, the failure to supervise, in my view, is really placing the burden on the prosecution to show that there was a defect in the company's corporate culture or in the compliance efforts, et cetera, so there was a failure to supervise. Whereas if you have a more flexible approach where the act of even a low-level person acting on behalf of the company can trigger the liability, then it's up to the company to prove that, yes, this did happen, but look, we really did do our best. We have extensive compliance efforts, extensive training, and, like as in the US example, for instance, we detected it, we reported it, we came and helped you cooperate, we cooperate with you in this investigation. I think the broader the rules of attribution, the more powerful the corporate liability regime is in terms of encouraging detection, encouraging cooperation, encouraging remediation in the long run. And that's just my personal belief. You will not find anyone in the working group that will say that. But I will point out that I did work on the evaluation in Norway, phase 4, and there's a court case discussed there, the Norconsult case, where the Supreme Court majority and minority diverged I believe, on how to apply corporate liability in Norway. And both sets of the majority opinion and the minority opinion both followed the two different prongs of the flexible or functionally equivalent approach and came to different outcomes. So I think that's actually quite telling. And just just to conclude, like I said, I know it's a lot of work. It is a really ambitious thing to try to reform a legal system and to have the buy-in from all the practitioners and from companies and other parts of society that may not welcome it. I just wanted to thank you again for inviting me and to wish you luck in this effort. So thank you.
Дякуємо, пане Брукс.
Thank you, Mr. Brooks. We do have Tatiana Havanska online with us, but we've just agreed that considering the time limits available, we shall start our discussion, and if we'll have any issues that would require her expert appraisal, then we would invite her. As you've seen, we have people around in our round table who were present at our focus groups, and we are, I don't know how to call it. We encourage everyone. Okay, so we encourage everyone to participate in our discussion. And what we've discussed in the focus groups, those discussions we've heard today, the experience of the foreign countries, whether it helped us in order to take a more kind of final decision, that's a question. And as the result of our debate today, we should have a decision later on which concepts do we try to approve, whether it's going to be a criminal liability or a quasi-concept or administrative liability, or that should be incorporated into criminal code, or that should go as a separate regulatory legal act or law, because all of our activity is designed to make sure that the Special Anti-Corruption Prosecutor's Office would be able to investigate those crimes and offences. So it's your point on where we are moving towards is important, but we would also like to pass the floor to our academicians as well as to the representatives from the bar, because the defendants and prosecutors' position is important, and having a solid basis for further actions is very important for our joint work in future. So let me invite everyone to have the discussion. I would also like to say that we have Mr. Halidun and Robert Sievers, he was somewhere with us, and many others. So they were introducing different parties. They were like Christopher Columbus in this activity, and they've started this issue of the liability of legal entities. So if you have anything to tell, please, you're well invited. Thank you. And then we'll do the voting, by the way. So, dear colleagues, greetings. My name is Alexander Volkov. I work at the Asters legal company. I'm the lawyer of the state of New York, but a couple of years I've been working in Ukraine, and over this past 10 years, I've spent 6 or 7 years dealing with the investigations of FCPA related to the corruption facts and the use of this law on the territories in this part of the world. From my experience, I would like to focus your attention on the philosophy. First and foremost, in order to identify which liability should be pursued with, either criminal or administrative, in the end of the day, you would need to understand what do we have to receive as an output. Should we take a look at the concept of the US? Now, their approach is all about the fact that, on the one hand, You would need to make sure the company still be able to run and operate, even if such company like Siemens, for example, even if they were engaged in serious acts of corruption. You've all seen the fines they paid. Now, it doesn't mean that this business has to be stopped or terminated completely, because the large companies, they employ a significant number of people. On the other hand, we understand that the legal entity is something that does not exist. People are the one to take decisions. So even decisions related to corruption is something that are made by the people. So if we're talking about people, like individuals, they take full criminal liability for the actions they've taken. Speaking on the legal person, it also is criminally liable, but it's not the issue whether it has to be sent to prison or not, but which actions of influence against this legal person has to be introduced. As a rule, when the investigation starts, the FCPA, well, for example, like all people that has something to do with the matters important for the investigation, they're sort of put aside, and these persons, they protect themselves independently in the court. So there's not the case like the legal person would be covering or protecting those people working in such companies or who are the owners or somehow related to the case. On the other hand, how it works in the United States, that the legal person tends to investigate itself in many cases, and then the law enforcement agency's role would be to navigate in this investigation, and the courts make sure there's the comprehensive investigation. The company unveils everything it has internally, and in the end of the day, we are having some sort of agreements, and based on these agreements, the companies are paying the fines, and then the individuals who committed those misconducts, someone may go to prison, someone may pay fines or penalties. So the system works pretty effectively, and the major question is how to ensure this balance of interests with the state that has to stop this activity or misconduct. And on the other hand, there's this balance of interests of the business, so that the large companies would remain operational, would remain in a condition that they can continue to develop and undertake its economic activity, to continue employing people. So, Alexander, which model would you suggest for Ukraine? Well, I believe that the most effective is the criminal liability. That's definitely, but the question is not only about the title or the name. It's all about the mechanisms of liability, and more specifically, the sanctions that are imposed. The criminal liability is clear. It does not require any philosophic changes to the approaches to administrative liability. Besides, historically, it's of a different nature, of a different type. The bribery in Ukraine and everything related to that, even now, during the war, it causes a very significant social need in criminal punishment for those perpetrating bribery and corruption. So, looking at my experience, which is more of a practical one rather than theoretical, I believe that criminal liability is very effective and could be very well implemented within the tools and within the system of institutions that we have now. Meaning the Special Anti-Corruption Prosecutor's Office, the Special Anti-Corruption Court, and all the other specialized institutions, and they will harmonically function in a system of law enforcement agencies who have already proven their capability to effectively fulfill their functions. Thank you, Alexander. Now, taking the opportunity that I'm so close to the judge of the Supreme Anti-Corruption Court. So thank you, Paulina.
Thank you. It's been really interesting to hear the speakers today. I would like to add a few words about the current state of affairs. Indeed, as of now, the Criminal Code of Ukraine has a few articles which provide for criminal responsibility of the legal persons, and there were many academic articles that it's not effective enough. In our court, the High Anti-Corruption Court of Ukraine, we have a few cases where, according to the indictment, we might apply criminal measures against legal persons. But as far as I know, we haven't had any verdict. And in my opinion, the current articles have issues because, firstly, the terminology needs improvement. There's this famous term, on behalf and in the interests of the legal person. It needs improvement or even change or interpretation in the case law. Secondly, there's a limited number of crimes for which these measures can be imposed. For example, 364, 191, the articles on embezzlement or abuse of powers or misappropriation of property, they do not, they are not linked to the possible criminal responsibility for legal persons. It's only international corruption when the person is located outside of Ukraine and they get some legal benefits in Ukraine that can be fit here. Another procedural problem is that the investigator who, in the beginning of this legislation, and even until now, the investigator doesn't want to overcomplicate the case with a parallel proceeding against a legal entity, especially considering that the businesses love creating hundreds, well, not hundreds, but a lot of shell companies. When one company has some production assets, the other is responsible for manufacturing, the third is distributing, and there are whole chains of entities. With regards to the model, I think we can improve the existing notion if we have some international obligations. We can indeed have the autonomous regime of criminal responsibility for legal persons. And now, in the criminal procedure, we've had some spot things. For example, Part 8 of Article 284, saying that criminal proceedings against the legal person goes in parallel with the criminal proceedings against the natural person who has been indicted. If we change that clause, we can even have autonomous proceedings without the parallel proceeding against the natural person. And There are some differences there, but some of the articles are shared, and we need to think of all the use cases. When we talk about criminal proceedings against the legal person, this, well, it would be the beyond reasonable doubt standard of proof, and it would be not so easy without having the indictment against the natural person. But, for example, when the natural person is not available for criminal proceedings, perhaps then it can be allowed. For example, if the person died, if the natural person is dead, or entered a plea deal, or, for example, it's part of a separate proceedings against persons who acted on behalf and in the interests of the legal entity. With regards to the administrative process, we have quite a tool set which is similar, for example, the anti-monopoly proceedings or tax sanctions. When an administrative body sanctions a company and they can appeal to the court. This also is a possible way to go if it is implemented. But if we talk about the judicial appeal, we know that the European Court of Human Rights had been looking at the anti-monopoly or tax proceedings just as criminal proceedings. So the proper defense tools should also be available, the same as in criminal proceedings. Inaudible. Yeah, so thank you so much for the opportunity to speak at this event. I hope Alexander Gudun will add to my comments. Polina said that many of the people here, they are just opening new lands for Ukraine, just as Columbus did. I remember we started this, and we even ran training on legal responsibility for legal persons. We've published quite a lot of research articles, and the last time we've had this training was in 2019. Then we went to work in different institutions, but back then, when we've had these trainings, there were two verdicts where the criminal responsibility measures were passed against the legal person. One verdict was in Donetsk Oblast, the other, I think, in Zhytomyr Oblast. What was interesting is that there was the violation in the procedure for these measures, which is now outlined in the CPC. And one of those verdicts had been appealed due to undue process. But the Court of Appeals have supported the initial verdict, even though there was a violation of the procedure. So I want to say that it's really difficult to apply the mechanism which the current criminal code provides for. And preparing this event, I monitored the register of court verdicts, whether the situation has changed, whether there are sentences, but no, there are none. These two original verdicts, we managed to have the links to them, and they are essentially the only verdicts against companies. It's obvious that we need changes to this institute, and the anti-corruption strategy had provided for the implementation of the autonomous responsibility of legal persons. But while the legislation is amended, we need to apply the existing norms of the criminal code and the CPC. So Ms. Tradnova and other responsible persons who can implement this training in their programs, the training on applying these measures. I'm sure it will be very, very useful for our law enforcement bodies and other investigative bodies. So if we talk about autonomous regime, I think it's more appropriate than the existing quasi-criminal liability. Once again, if we want to be at par with other countries and considering the difficulties with the implementation of the current statutes, we probably should develop some justification in the doctrine saying that the criminal responsibility of legal persons and whether it's aligned in the current whether it's aligned with the current law. We have the principle of personal responsibility in the criminal law, and we need to overcome this principle in order to introduce criminal responsibility of legal persons. So I think the administrative responsibility is the way to go for the autonomous regime. Thank you. Yes, thank you so much for inviting and giving me the floor. Indeed, if we talk about the responsibility of legal persons, we must also give some context and how it came up to be and how it ended up in the national legislation. And indeed, the legal doctrine in Ukraine do not enable criminal responsibility of legal persons because the general idea of the subject of crime is different. And the researchers, when we discussed this model, mentioned that. That's why, considering those axioms, this hybrid model or the quasi-criminal model had been selected. But also we need to consider that the grounds for applying these measures in the current legislation are much wider than had been discussed today. It's not only about corruption crimes. Now we can also talk about criminal offenses related to corruption, and also it's terrorism, so crimes which can be committed on behalf of the legal person, and if the legal person is an accomplice, then the liquidation and full seizure of the assets is the sanction which is provided. And the latest trends in this sphere show that quite often when amending the criminal code, when new crimes are introduced or old crimes are revised, the legislator tries to expand the grounds for the application of criminal measures against legal persons. Indeed, we do have some conventions which put the obligation on Ukraine to move in this direction, but in other cases, we just have this initiative on our own, and sometimes it's not fully justified. But there are quite a lot of draft laws which are aimed in particular at the expansion of the grounds to apply these criminal measures. We must also understand that any prosecution against a natural person or a legal person can be done within a case, within the proceedings. And Mr. Benchuk has mentioned a peculiarity of our system. The administrative liability can be considered following the Code of Administrative Justice. But if we talk about quasi-criminal proceedings, it can only be done within the Criminal Procedure Code. and the clause that it has to be going in parallel with the proceedings against the natural person, which was the agent of the legal person. Then, of course, it complicates the procedure of holding the person accountable, because in some cases, indeed, the investigators and prosecutors do not want to overcomplicate the case with additional circumstances, and the all must be proven according to the standards of the criminal process. On the other hand, if this matter had not been solved in the pre-trial phase or in the trial phase against the natural person who has committed the crime on behalf of the legal person, then in the future it's not possible to resolve the matter of the liability of the legal person. Even if we have the verdict against the natural person stating that, yes, this person has committed a crime, and at that moment they were acting on behalf of the legal person, and the legal person has received either some illegal benefit and so on, that would that is how it is, and this should be resolved. And at the moment, I would say it needs lots of improvement, so to say. We know that there are other problems. For example, if the court decides to close the proceedings against the natural person, automatically the proceedings against the legal person also is closed. But we remember that we have this kind of division into exonerating and non-exonerating reasons to close the case. And the Constitutional Court has referred to this. And sometimes, even if the natural person is exonerated, well, then the proceedings against the legal person is closed, even though the legal person could be still an accomplice, and some measures must have been applied. So, with regards to these measures, it takes a lot of discussion, and the existing system is not exclusive, because it has only one main measure and one additional measure that can be applied. But the international experience shows that other effective measures could have been possible if the legal person enabled the offense by its agent. For example, a ban on some types of commercial activities, or a temporary ban on the participation in state contracts or biddings. It would have been an effective measure too, an effective measure against the legal person who had been incompliant with anti-corruption legislation, and which did prevent the offense by its agent. And there are quite a lot of issues still, but hopefully with joint efforts we'll be able to find the solution. Thank you, Alexander. I will not be pressuring NABU and SAPO now, because I understand that it's difficult to take any decision now, but I would still ask you, for the sake of today's event, if you could perhaps think on what could have been a more effective model. Now, having all the cards at hand, if we could do something to implement this responsibility for legal persons. Yeah, over to you, Andrei. Greetings, colleagues. Well, if we have political will, if we want to join this esteemed international organization, and we need to amend the legislation, I think we need to follow two principles here. Firstly, this is the do no harm, as the doctors have it. Do no harm for the investigators, investigatees, and the judiciary. And the second principle, let's not reinvent the bicycle. Having heard the international colleagues, for example, we are now in a better situation than the Italians, for example, who didn't have it at all. So we already have the rule. It might be far from perfect, yeah, sure, but still, in the criminal code we have the concept of the responsibility of legal persons. Yes, it's far from perfect. Yes, it has to be improved, but we have it. That's why I think we don't have to reinvent these quasi-criminal additional process or leaving it for administrative justice, because they also will have many questions on how it shall be run and so on. My position is keep it as it is, a part of the criminal process. Just if we talk about the criminal responsibility of legal persons for corruption activities of its agents abroad, if we analyze our criminal procedure code and criminal code, well, I would say there are not so many changes that have to be introduced.
Thank you, Andrew, and anyone else. My name is Lebed Ludmila, the lawyer from the Lawyers Association. I fully agree to the previous remarks, and during the previous roundtable, I had a position that it's impossible to introduce additional amendments to the Criminal Procedural Code of Ukraine, since it's going to be too complicated and too obscure, and since we do have investigation against legal entity, and that might be delayed for years, and that's not effective for sentencing the legal entities. But when I've learned the foreign experience and having listened to the points of the counterpart, the Criminal Procedural Code of Ukraine clearly set the directions, and with minor changes, it already provides for the liability of the legal entity. Now, the question is that we do have to take into consideration our legislation, the things as they are in Ukraine. Now, we can settle this matter, and should we apply the same procedure to the legal entities as to the individuals? That is, when the criminal proceedings is initiated against both against the legal entity, legal persons and individuals, we can do some precautionary measures, meaning from our own experience we know how painful it is against the individuals, the application of any precautionary measures. For example, if they're detained, if on this stage against the legal entity to which this individual has a relation to, if there's a precautionary measure like an seizing or temporary freezing of some assets, or the changes in the articles of association, or any changes into the other registration papers, then that's going to be very effective, that's going to be very swift, and to a certain degree that would be a kind of a precautionary measure, but still the legal person would definitely feel this, because in the process of investigation the legal person would be feeling that burden, and besides there could be stringent sentencing against that legal person, so that they would understand, they would make a plea deal, and we can take, for example, the US approaches, because I think we need to take what's best is there in the foreign countries. And for example, if the person recognizes responsibility, and so the prosecutor's office is not proceeding with the sentencing, and that stage everything is terminated. So my vision, from my experience, and looking at our legislation, we have a kind of a more favorable position if compared to those countries that we've heard about today. And I think that it all has to stay within the framework of the criminal procedural legislation, because it offers some benefits in terms of proving the person's guilt with sufficient evidences, and positive against the legal person, because there's not going to be just accusations or political influences, but surely there has to be everything in accordance to the Criminal Procedural Code of Ukraine in order to make sure that none of the rights is violated, and the burden will be placed upon the prosecutor and for the judge, but that's going to be a fair lever, so to say, particularly in terms of understanding whether there need to be some precautionary measures imposed or not, based on the type of evidences and many other aspects. So sometimes there could be negotiations, as it is in the United States, whether the legal person would be willing to have the investigation continued, and if the precautionary measures would be properly identified, if we'll have a special chapter on individuals. I think that would be the swift response to the misconduct and violations, and that would be the mechanism that would allow to make the right decision what to do with the criminal proceedings. Should we take the US experience, then I think for the legal person it would be far more beneficial after the judge would make a sentence to sit at the negotiating table, to reimburse the damages, and then to terminate the proceedings at this stage. Thank you, Ludmila. I tried to set a sign to Nabu and Saab. What do they think of that? Maybe I've explained it in too complicated manner. No, thank you. Now, before we conclude, is there anyone else who would like to say? Bogdan, you've raised your hand. And then I would like to ask our community from the NGOs, TI, CPK, you would like to say anything else? Is that so? Bogdan, we'll start with you. Thank you. Holovko Bogdan, the Legal Association Sayenko Kocharenko. Well, if I absolutely agree with my counterpart, sending a detaining person for 60 days surely would make the people agree to a plea deal in order to save the business. But I mean, I'm joking. I understand. I mean, arresting the accounts, and surely the people would try to make a plea deal with the investigation. That's 100%. I'm not arguing with that, but I believe there could be a search for other approaches, but that might work. And I was listening to the previous speakers, and I looked at some of the aspects, and some of the problematic issues that we would need to identify as bullet points. First, in accordance to the current legislation, the person that could be a suspect in criminal proceedings, that could be a person that could be identified as the representative of a legal person in criminal proceedings. That's Article 64, Paragraph 1. That's in terms of the plea deal and etc. You have 90% of the proceedings, for example, a CEO or any official of a legal person. It's a subject, so he'll be informed as the suspect, because that's how the businesses works. In public joint stock companies, there's not too many CEOs and other officials, and there could be the owner of that business and the CEO, and he will be the representative of the legal person, because that's the definition as we have it in Article 64, Paragraph 1. But what do we have in reality? That's from what we've heard from our expert in the United States. In most cases, we are about to have a sentence, but we sign a plea deal without going for a sentence. Then we agree, then we pay fine. Why isn't it going to work in Ukraine? Because when you have a CEO who's going to be liable under the Article 369, and he is a representative of the legal person, then you won't have a plea deal, because that person understands that they have criminal liability for any corruption misconduct. It will defend himself to the very end. So, and then the criminal proceedings will go even in the Supreme Anti-Corruption Court for years, and the lawyers will work on that in order to learn the materials, and never the legal person would agree to that. Then, in accordance to the current legislation of Ukraine, you can't take a plea deal, because so that having a plea deal with the legal person, it's agreeing to pay fine, but if that's all the same, and the person is representing the legal person and it represents the suspect at the same time, then it's not working, and it's very hard to change it, because we understand that 90% of the criminal proceedings are not about the deputy head at the production facility. It's going to be the CEO, his deputy, or the accountant, or any other person. So that's what I would like to focus your attention to. Then what Dragokos was talking, he mentioned this law. In fact, he said over 10 years ago, back in 2009, they voted a law on the liability of legal persons for corrupt practices. It worked for 5 years, and then it was abolished in 2019. The concept was good, really. And you can find this law, you can read it. Well, it's kind of a rough, I would say, but it set some sort of a parallel procedure of bringing to liability. There was a prosecutor, they've filed a protocol, he went to court, and then the legal person has been represented in there. There were two moments that we've discussed on focus groups. What's the problem is about? First, this law says that he takes the sentence, the prosecutor has to take the sentence, and this is something that we've heard today, that there has to be a predicate, meaning if this works, then it works with the sentence or with the court decision against the physical person. We have to understand that our Ukrainian reality, that would take years. The pre-trial investigation, that's years of investigation. That's not going to work. So my personal point is that similar, to have a similar law to set a parallel procedure. But unfortunately, I don't know, it was abolished very soon, and there is no negative experience of it, but some was feared of that. But really, making kind of a step back, meaning without the sentence, but then we have to come up with the definition of what the legal person may be held liable for, and then to write the responsibilities of the prosecutor, because everything will still depend on the prosecutor's office, and still everything is going to be all about the data received in the course of the pre-trial investigation. And from the theoretical standpoint, it's written, but looking at the foreign experience, it's either you need a predicate, that is, you need a sentence, and in Ukrainian realities, it's something that it's hard to come up with. But taking plea deals, under Ukrainian realities, who would agree to that, and how it would work? In administrative proceedings, all of these cases of, if that's going to be not a claim, so there's something like that. All of that could function normally, and the prosecutors surely know how to sustain claims and things like that. If we'll write this all down, I think that would be effective. Now, Vitaly, you have the floor. So, good afternoon. First of all, thank you for the briefings. It was very interesting, and the matter is very serious. So my name is Vitaly Ochakovsky. I'm a lawyer representing the American Chamber of Commerce. We don't have a position yet. We haven't received a feedback from our companies. And just to remind that we're representing over 600 companies, primarily foreign investors who invested over 50 billion US dollars in Ukraine. The American Chamber of Commerce has a legal committee that I'm a co-chair of, and there is a compliance club. We're talking about foreign investors. These are the companies they who clearly understand what the FCPA is. They know what the compliance or the anti-corruption. And we offer to get a feedback from those companies and to make a presentation. And we are ready to offer the platform for having such an event. Thank you. No, well, if our colleagues from the INL, from DLO, if they don't have anything against it, then it would be a pleasure for us. Well, all of these laws will potentially apply to those companies, so I think they should be happy to provide their own feedbacks. Besides, they know how it already works in some other countries, so it's not something absolutely new for them. Besides, in case of the American Chamber of Commerce, we have over 1,000 of lawyers from the largest lawyer association, so surely you will be able to have some good feedback, and hopefully it can be fruitful, and we can establish a fruitful cooperation. Thank you. And Olena, you as the representative of Center for Combating Corruption, as an NGO, what do you think? Because it's really important, as it's kind of very important for our society. Well, thank you. There's a lot of particularities, and there's a lot to mention, but since we do have a limited time, I think one of the key challenges that we've seen today is this story that we don't have court cases that we could take into consideration to understand what goes wrong. We don't have court sentences, well, 2 court sentences in violation of the standing procedure. That's not something that you could come up with feedbacks. And sometimes you need to make a few steps back in order to understand what went wrong. And we need to talk about the series, the complex of changes. Now, why is it taking too long to consider those cases? If they're considered long and non-effective, then we need to solve this challenge. For example, the anti-corruption court, we have a lot of sentences in cases with 1 or 2 defendants. But in case of several defendants, in case of legal persons engaged, then the consideration of the cases may take a very long period of time. And if this is not settled, then we'll have a lot of challenges. That's why we need to come up with a comprehensive solution. I think the parallel existence of the administrative proceedings and criminal proceedings against legal persons, depending on the type of the misconduct obtaining of the complications, that could exist. We need to take into consideration the particularities of Ukraine, because one thing is when Siemens is about to be held liable and they have what to lose. And in Ukraine, for example, when we have tens or hundreds or thousands of some entities that were especially created for the shady practices, they don't have anything to lose, and in that case it's far more effective to bring legal persons to accountability. And talking about those steps back, I think there is a sense to come up with the analysis of those proceedings with the legal persons. We need to have a detailed analysis of what went wrong, why was it taking too long to consider those cases in court, and then to offer some options to accelerate the hearing process, as well as to see what sort of problems were there for the investigators and prosecutors. and try to take into consideration the court cases that we have, even without the court sentences. I think that would be the right approach. Thank you, Olena. We're supposed to have this round table until 10 past 5. So let us make the following. Those who haven't managed to deliver their statements will have a separate consultations with them, so we'll ask for their points separately. Well, there's not too many of us, but people who came in, they have a very specialized legal knowledge, and it's important for us as the members of the working group to listen to their point. And in conclusion, whenever we had a conversation with Sergei about the model and the concept, as we see that, we believe that our event has to end up with an understanding where to go, which directions to follow, and which decisions do we need to make. But I believe that this event has widened our vision, so to say, which is a wrong trend, I would say. But still, the voting that we would be doing, it would be all about what type of liability do you think we should implement. And there were two models, introducing amendments to the Criminal Code of Ukraine, as well as the implementation of the norms, an implementation of norms within the Criminal Code, or a separate law on quasi-administrative sanctions. But then we've heard today about the third concept, and we'll think of how to do that. That is to introducing changes to the current legislation on administrative legal actions and developing the norms on responsibility. And then when we'll have three concepts of legislative changes, then we'll share all those comments among everyone, and we'll ask for your feedback.
Зробити НАБУ.
Especially NABU, SEPO, and HSCC, and the Ministry of Justice, of course. Inaudible. The speaker from the Ministry of Justice is not using the mic. Yeah, and then after we will have more or less coordinated stances. I hope my colleagues from OECD would not mind if we share this document with them, and we would ask them to look at our proposals so that we would not be doing the same job twice. And then we would ask you to provide the feedback whether you agree that what we are going to do would be the path to the membership in the work group. So thank you for the participation in this meeting, and I'm sorry for overstepping the time a bit. I hope we all see each other again soon for further discussions. Thank you.